Okay, now we're moving on to foreign divorce. And in this case, we have Henry and Lynn, where they are living in the US, they're resident and domiciled in the US, but they still hold their Chinese passports, still Chinese citizens. Similar situation with the son and daughter, a daughter in the US, son in China, assets in China, in the US, and the Singapore Trust and the Cayman Company. The next question is, what is the basis on which the US court would exercise its jurisdiction in divorce proceedings? Would a US divorce court seek to redistribute or distribute or alter the community property rights? And whether pre and post nuptial agreements are legally effective? So John.
Yeah, so it's again state by state. It's typically a domicile/residence test to see where the couple is at the time of the divorce proceedings. Sometimes you can see one spouse go to a different jurisdiction to try to get jurisdiction in another state. The states tend to not like short-term residents because they don't want to be seen as divorce mill states, but it's going to be on a state-by-state basis for claiming jurisdiction around residents. Would they seek to redistribute or alter community property rights? Typically, no. The no fault versus fault concept in the US is really geared towards no fault. The idea of you don't have to prove something, you don't have to have a contentious issue, and along with that has been the concept of let's just follow the rules and spread things out the way that the law has said in the definition of marital property in that state. Now remember, that can vary widely though. It's not one federal definition 50-50. It can change from state to state what the assumption was, both for property coming into the marriage and property acquired during the marriage. And then pre and post nuptial agreements, I think we've already covered those. Just make sure those four elements are dealt with so that you don't have an invalidated agreement during the divorce proceeding.
Okay, thanks, John. Another question, whether US divorce courts may order division of the Chinese property and whether a US court order would be recognized and enforceable in China. Frank.
I think I'll start, Frank, just to set the tone there on whether the U.S. court would enter that order. It is possible, and actually, if even in absent of contention, you might get an order saying, "Here's just the standard thing that everyone's agreed to," and then you take that and try to enforce it. So yes, it is possible, and it can happen that the U.S. court would issue that, and someone would take that to a Chinese court to enforce or Chinese authorities to enforce.
Thanks, John.
Yeah. For the second question, if a court order in the U.S. has been issued, then PRC law, chances are they will not recognize and enforce it in China unless there's a treaty. But I don't think China and the U.S. has a treaty in terms of recognizing each other's court rulings.
Thank you, Frank.
Mm-hmm.
The next question is whether a US court may order a variation of the Singapore Trust, whether a US court would be recognized and enforceable in Singapore.
So from a US perspective, the concept of trust variance does, it is there under the common law. I would say it's not as it's not done as often as you might see, say, in a UK court. The point of entry from a US court perspective will often be a sham trust or invalidation of the trust rather than variation of the terms. So simply, if there's a point raised where there was never a trust to begin with, the court could take attention to that and shift property back to the ownership prior to the funding of the structure. Variation is possible, but less common, I would say, than perhaps Zach could comment on from a UK perspective.
Insofar as from the Singapore standpoint, there's no express firewall protection against a foreign court seeking to vary a Singapore trust in matrimonial proceedings. But it would be a matter of comity, I think, from the Singapore court's perspective as to whether they would actually go ahead and enforce that. And we've seen some of that in the Channel Islands, where notwithstanding some of these firewall protections, the courts will as a matter of comity, go ahead and enforce a foreign order against a domestic trust. So it would be a matter of comity, but even under Singapore domestic law, there isn't the concept of a sort of ante and postnuptial settlement under the Matrimonial Causes Act, or the version there, in the same way as I think they have in Hong Kong. So I think it would be a matter of comity as to whether or not that would be recognized.
Thanks, Zach. And then also whether Cayman would recognize and or enforce a foreign matrimonial order.
Yeah, I think the same thing. There would have to be as a matter of comity, because these are non liquidated or sort of liquidated damages or cost type claims. So these are property reallocation claims. So again, it would be a comity claim. But if I think if Henry, let's say, is the individual owning the shares, if he's still in the jurisdiction of the US courts, then presumably, and John can hopefully back me up on this, if Henry is still in the US jurisdiction, they would just simply order him to transfer the shares upon pain of being in contempt of court.
Correct.
So yeah.